Good morning. Little bit jurisprudence, and particularly because elections are approaching, the candidates must know basic principles of constitution, customs law, so many things, and several our advocate friends are contesting elections. So this I will see. Constitution is differs from legislation. So far as legislation finds its authority in the Constitution, while Constitution is the wholesale source and its authority lies in the political fact that has been so accepted. Constitution may be the fundamental law of the land, or it may simply be political document. Our Constitution is fundamental law of the country. Its provisions lay down binding rules, violation of which can be checked and remedied through court action. But there are constitutions like that of China, which simply lay down the rules for the guidance of the governance of their violation may be checked only by the political level. This is what the constitution. Then custom. What is that custom? Custom is the oldest and most important source of law. Though its importance is now diminishing with the growth of legislation and precedent. Custom means uniformity of conduct of people under like circumstances. Holland says that custom is generally observed course of conduct. Solomon says the custom embodies principles which are acknowledged and approved, not by the power of the state, but by the public opinion of the society at large. Then Herbert Spencer. Before any definite agency for social control is developed, there exists a control arising partly from the public opinion of the living and more largely from the public opinion of the dead. Thus, it is tradition passing from one generation to another that originally governed human conduct. That tradition is called customs. Keaton defines custom as those rule of human action established by usage and regarded as legally binding by those to whom the rules are applicable, which are adopted by court and applied as a source of law because they are generally followed by the political society as a whole or by some part of it. According to Hallsberg theory, custom is some kind of special law which is actual existence or possibly followed from times memorial and which have acquired the force of law in specified territory, although it may be contrary or inconsistent with general law of the land. So what happened? Custom necessarily involves two conceptions, namely conviction or faith and constant use. It is presumed that customs must have been followed on account of their utility and also because they enjoyed the express and implied sanction of the society. Custom played considerable role in the evolution of early law. It provided material for other law constituting agency, especially legislation. Psychologically, it is easy to secure obedience for the code if it is based on established custom. It is too great an effort to create law de novo afresh. It is always necessary that the courts should recognize all the practice which are prevalent in the community as a custom. In other words, such customs are not obligatory. Wearing black clothes at a funeral procession, on the other hand, there are certain customs which are binding and are enforceable by court of law since they are backed by sanction of the state. For instance, Hindu marriage solemnized without performance of Satpapadi is not legally valid and can be set aside by the court. This is what, but in Tamil Nadu, this question of Saptapadi is waived. Swayamariyade marriage was introduced. Best wishes.